my security system at this house. My security system is linked to my phone, so I couldn't access this house. So we don't know what they were doing here. We don't know what they were doing. That's why we haven't seen my family here.
On May 19th, 2022, former Lusaka Province Minister Bowman Lusambo reclaimed his property in Lusaka's Chamba Valley, which was seized by the Anti-Corruption Commission (ACC) pending determination of the investigations by the Commission. This was after Lusaka Magistrate Albert Mwaba quashed the warrant of seizure which was given to the Anti-Corruption Commission. Magistrate Mwaba had ruled that the said warrant of seizure was irregularly issued as an affidavit in support was not filed in court as required by law. He said even if it did, it could still not be in order to have both warrant of seizure and restriction notice on the same properties in force at the same time. In opposing the decision of the court, the Director of Public Prosecutions, DPP Lilian Siyunyi, has filed a notice of appeal against the ruling. Among the grounds of appeal, the DPP says the court failed into error by holding that both a warrant of seizure and a restriction notice issued under the ACC Act No. 3 of 2012 of the laws of Zambia have the same effect. She says the court also erred in law by holding that the warrant of seizure was irregularly issued as an affidavit in support was not filed in court as required by law, when there is no legal requirement for a warrant to be supported by an affidavit under the Zambian law. The DPP has also attached an application to file such an appeal out of time, claiming that our office did not have the case record on time. Further, the DPP has filed a notice of appeal against Magistrate Jennifer Walia's ruling to discharge former Housing and Infrastructure Minister Chitotela'S on 2 counts of possession of property reasonably suspected to be proceeds of crime. According to the DPP, the trial court erred on point of law by discharging Mr. Chitotela'S when it held that arraigning him after a settlement would amount to double jeopardy before invoking Section 277 of the CPC, Chapter 87 of the laws of Zambia. She has submitted that the trial court also misdirected itself in a point of law when it held that arraigning the accused was tantamount to double jeopardy as provided for under Section 138 of the CPC Chapter 88 of the laws of Zambia, when no plea was taken before any other court of competent jurisdiction for purposes of trial, among other grounds. Darius Jonya, Diamond News.